I'm Vic Amar. I'm the dean here at the College of Law, if I haven't had a chance to meet you yet. And, when I got here at the university 4 years ago, one of the thoughts that I had was that law schools in America need to be better integrated, not just with the great research universities of which they are a part, but with the professions that they serve. And we're a unit on campus, and we can never forget that. We're part of this great university, but we're also a unit within a great profession of the law. And so it's been my pleasure since I've gotten here to invite and welcome a wide range of thought leaders in government, as today's speaker is, in the private legal sector, in the business sector, in the nonprofit sector. And I think it's important for us to understand how the things that we talk about in the classroom and that we write about in the law reviews are being used, or maybe not being used to full effect, by consumers who are in policy and private arenas. So with that, I want to really give our speaker today as much time as possible. Let me briefly introduce him. Jason Barickman is an Illinois senator from the 53rd District. He was elected to the Illinois State Senate in 2012, 7 years ago. He represents a district that includes Ford, Iroquois, Livingston, McLean, Vermilion, and Woodford counties. He already occupies several important leadership positions in the Senate. He serves currently as the Senate Assistant Republican Leader, the co-chair of the Legislative Audit Commission, minority spokesperson on the Judiciary Committee, and is a member of the Criminal Law, Education, Executive, and Labor Committees in the Senate. He was raised on a family farm in Livingston, is a proud veteran, having served as an infantry soldier in the Illinois Army National Guard. He's packed a lot into a very short time. He's still quite a young man. He's a graduate of Illinois State University and, of course, and importantly, our College of Law here. He was a graduate in the class of 2005. And he, in addition to the important work he does in Springfield, he's a partner at the, I think, the largest law firm here in town, Meyer Capel, where he focuses on real estate investment and development. He teaches state and local government offerings at Illinois State University, but we were chatting earlier, and at some point I think it would make mutual sense to have him here teaching as well. Senator Barickman has been honored for his work in the Illinois General Assembly from agriculture and business groups. He's an advocate for education reform, and is also a graduate of a very, I think, important and well-conceived program here at the College of Law, the University of Illinois, Urbana, and that's the U of I Edgar Fellows Leadership Program. So with that, let me welcome Senator Barickman to the podium and let him offer some thoughts.
Well, good afternoon. Kind of a start, right, Kelly? Right? Just like when Kelly and I were in school here, right? You got to get the class warmed up. So, thank you, Dean, for the introduction and for the invitation to speak. This is when you're in politics, you get offered a lot of opportunities to speak. Sometimes at a moment's notice. Oftentimes, 99% of the time, when I show up at an event, I've given about 10 minutes of forethought to what I might say, and then I kind of go with it. That's the good and bad, I suppose, of politics. You learn to do that on the fly. With today, I asked my wife, I said, who's also a graduate of the College of Law here, I said, what do you think I'd talk about? She said, well, just don't give one of those political speeches that you're always doing. She says, she says, you're going to have some faculty in the room. You never impressed them when you were a student. Now's your chance. She said, there's going to be students in the room, and you want to encourage them to aspire to greater things, not, less. And so she said, really give some thought to what you're going to say and what the topic may be. And so that's what I try to do. I think there's a title that was published. I don't even have it in my notes, but generally what I thought was that we should take this afternoon to really do a critical analysis of the state of Illinois Constitution. And maybe some of you students are in con law, which really focuses heavily, at least when I was here, on the United States Constitution. But I've always thought it's important to recognize we have a state constitution, and it plays an incredibly important role in the governance system of the state. So we'll see where this goes. We're not quite there yet, but July 1st, 2021, a few years into the future, is a very important date for our state. That date marks the 50th year anniversary of our Illinois Constitution. So as we approach the milestone, I thought, let's use this time to begin to critically assess the document, the Constitution, that effectively controls the exercise of political power in Illinois, and ask ourselves whether that Constitution is doing the job that we intend it to do. So first, some history. Some of you may know this, some of you may not. None of you were there when it started. There have been 4 constitutions in Illinois, the first in 1818, then 1848, 1870, and the most recent one, which was adopted by the 6th Illinois Constitutional Convention on September 3rd, 1970, ratified by the people of the state on December 15th, 1970, and went into effect on July 1st, 1971, hence the 50-year anniversary here in about 3 years. Many here, I wasn't again, but many here may not have been born in 1970. Were you? Nope. See? Tom? Yes. Professor Ulan was. Anyway, 1970, that's when our Constitution was adopted. You may be surprised to find out that it only has a fraction of the history that our U.S. Constitution has, right? We think of constitutions and we think of these incredible legacies that they leave, the roots embedded in history, and then we recognize that in Illinois our Constitution is really not that old. It's less than 50 years. So our Constitution has evolved over the years as our state has evolved. Our first Constitution, again, 1818, included provisions that were largely in use from other states. Effectively, we stole ideas that other states had in practice at the time. Our first Constitution embraced a weak executive, the governor's office. Our Constitution said initially the governor's office, the executive branch, should be very weak. They gave the governor a veto that was very limited in actions. In fact, the first veto powers of the governor were only allowed to be used if used in conjunction jointly with the Illinois State Supreme Court, which really shows you how weak that veto power initially would have been. Amendments to the initial Constitution were only permitted in very limited circumstances, basically if voters called for a state constitutional convention, which is a very difficult process to do. You'll hear more about that in a minute. So Illinois rapidly expanded. The state quickly found itself in lots of financial troubles. We're still there, but we also were there back in the 1800s. What happened then? In the early 1800s, state banks, Illinois had a state bank, multiple state banks. They failed. There was an expensive infrastructure program. Sounds like something similar to today, but there was an expensive infrastructure program designed to spur railroad construction around the state. That program collapsed, and the public at the time, again, this is the early 1800s, they began demanding a more Jacksonian-styled, populist style of government that elected people who were commoners as opposed to kind of historically what had been done, which was the elites, right? So this was Illinois in the early 1800s. The 1848 Constitution comes along. It has lots of new restrictions on legislative powers. It gave more power to the governor, especially in regards to his veto. It placed limitations on state debt, and it chose the selection of judges through an election process as opposed to an appointment process, an issue that we still wrestle with today. Importantly, the constitutional amendment process became a bit more liberalized or open, giving power to people to amend that important constitutional document. However, it's often stated that the 1848 Constitution it had lots of details to it. It is a very detailed Constitution, so many so that many people thought it soon became outdated and inadequate for solving the problems of the state in the mid and late 1800s. So along comes the third Constitution. Now we're in 1870. It embraced lots of ideas and in fact worked for the next 100 years. Until 1970, we had the 1870 Constitution in place. It liberalized the legislative process. It used a multi-district House that permitted minority representation. Some of you are more familiar with that issue than others, but I'm going to come back to that towards the end here. Gave the governor appointment powers, a stronger veto. It expanded the Supreme Court to 7 members and added a public education article, which we still debate in the legislature today. Interestingly, the Constitution also made the amendment process more restrictive. Where it had been going down this track of liberalizing that, it actually restrained it. Regardless, the 1870 Constitution, it lasted 100 years and generally was well regarded by constitutional theorists and pundits who thought that that Constitution did a good job of ending special legislation, stopping municipal spending schemes that got the state and its municipalities in lots of financial problems, and it otherwise responded adequately to the issues of the day. Finally, I guess I should mention that there were efforts along the way to enact new constitutions that failed. As an example, in 1862, there was a constitutional convention. There was a group advocating for pro-slavery provisions to be included in the Constitution. This was known as the Copperhead Constitution. That one was never ratified by voters. Go Illinois voters, right? We make some good decisions sometimes, just not always. Okay, so 1970 comes along. We've got a constitutional convention. That led to the 1970 Constitution. That's the Constitution that we have in place today. I like to think that the official starting point of that convention was really at least 5 years earlier. There was a Constitution Study Commission that was enacted by law back in 1965. There was probably a ton of behind-the-scenes work that even went into that study commission. Government is a slow-moving process. So the notion that we might enact a constitution in 1971 that started with a study commission 5 or 6 years earlier and probably lots of legwork in the years before that, to me, though sometimes it's frustrating, is not overly surprising. That's the way government tends to work. Okay, the study commission led to a chain of events, including a proposition for the calling of a convention presented to the electorate in conjunction with the general election on November 5th, 1968. Tom, were you there then? Yeah. Okay, good. That one passed. I won't ask you how you voted, but or if you were old enough to, young man. The proposition easily passed, 2.9 million votes in favor, 1.1 million against. 116 convention delegates, 2 from every Senate district, were elected the following year. Now, I want you to think about this, right? Imagine if we went through this today and we elected 116 people around the state to represent us in a constitutional convention. You are probably envisioning who those people might be, what they might look like, what their views may be, what their professions might be. Consider those who were in the 1970 Constitution. Of the 13, well, we got 13 million people today, not nearly that many then. Of the 116 delegates, Democrats and Republicans were almost evenly divided. There were 13 African Americans, 15 women, 56 were Protestant, 35 were Catholic. Lots of professions, some professions represented well, including teachers, farmers, and business people from around the state. As students, we all learned about the founding fathers of the United States, right? People like John Adams, Ben Franklin, Alexander Hamilton, Tom Jefferson, James Madison, George Washington. These are the founding fathers of the United States. Notable members of the Illinois 1970 Constitution. I'm waiting for the groans. These are the framers of our current Illinois Constitution. Names that may or may not surprise you. They included comptroller and gubernatorial candidate Dawn Clark Netsch. I think she lost in an election for governor to Governor Edgar. My mentor, by the way. Side note, footnote in a law school. Former Mayor Richard M. Daley was a delegate, and also was the current Speaker of the Illinois House of Representatives, Mike Madigan. In fact, Speaker Madigan, has served in the Illinois House since 1971, the first year the new Constitution was enacted. He's served since then. He's the longest-serving leader of any state or federal legislative body in the history of the United States, having held the position of Speaker for all but 2 years since 1983. I was born by then. So, Article 14 of the current Constitution asks that Illinois voters be asked every 20 years if they desire a constitutional convention. It's a question that's placed on a general election ballot. Do you want a convention or not? In 1988, the first time it was called, 75% of the voters voted no on whether Illinois should have a constitutional convention. Then in 2008, the vote was closer, but it still failed with roughly 67% voting against calling a convention. Again, in 2028, we'll be asked this question again. Okay, I think it's important to understand the purpose of a state constitution as well, especially as we compare the state constitution against a U.S. or the federal constitution. The dean mentioned that I teach a class at ISU, at Illinois State University, and I always tell my students, you've got to understand the differences, state constitutions, federal constitution. So, what are some of them? The U.S. Constitution, enacted 1787, it's only been amended 27 times. States regularly amend and sometimes replace their constitutions much more frequently than the federal government. Again, Illinois has had 4 constitutions. Louisiana has had 11. Our U.S. Constitution is very short. It's about 7,400 words. State constitutions, in contrast, are very long. Illinois is about 17,000 words. New York and California, clearly much brighter than us. They have 50,000 words in their constitution, but that all pales compared to Alabama that has over 117,000 words in it. State constitution, the words gives this away, but they're usually much more specific. We all know the U.S. Constitution reserves certain rights to the federal government, sets forth the national framework, and then through the 10th Amendment, what do? Set up everything else to the states. Say, states, you decide. The states, therefore, then have to address public policy issues in much more detail. They generally embrace a more direct type of democracy than the representative type of democracy that we have at the federal level. Okay, so why is this all important? It's important because we all have to have an understanding of the purpose of state constitutions and the history of our Illinois Constitution before we can evaluate its effectiveness. I believe the threshold question is whether our Constitution provides the structure for an effective and representative government, and ultimately, whether our Constitution allows for a true expression of Illinois' public will. Okay, brace yourself. I want you to consider some of the following things that we're all, if we're paying attention, that are in the news today. The redistricting process, which occurs every 10 years, is set to begin in Illinois and around the country in 2020. Following the 2020 census. Our current process in Illinois permits incumbent legislators to draw the district boundary lines. This is an important issue to many voters around the country and has resulted in lawsuits that have reached even the United States Supreme Court. A few years ago, a bipartisan coalition of Illinois voters collected more than 563,000 signatures, including mine, on petitions to place an amendment before voters which would allow voters to decide whether to change the redistricting process. The Illinois Supreme Court, in a controversial 4-3 ruling, found this effort unconstitutional. Effectively, the court said to the more than 500,000 voters who signed these petitions and everyone else who supported the effort, they said, our Constitution doesn't allow you to do what you are actually trying to do. Show of hands. How many of you think, you answered this question with your giggles earlier, right? How many of you think Illinois is challenged with its finances? At least 1 or 2 of you, right? Okay, whatever political party you identify with, if any, whatever metrics you use, most people agree Illinois needs to do a much better job of getting its financial house in order. That's not entirely lost on the General Assembly, though sometimes you all wonder whether we actually even get it. Although a minimal step over the last decade, the Illinois General Assembly has voted to freeze cost of living increases and implemented furlough days for themselves and for state office holders. Generally, the idea was Generally, this is an attempt to reject what is an automatic pay increase to the General Assembly. General Assembly members, we're people too, and we also realize you can't go home back to your district and report about a budget crisis and have that accompanied by news that you're getting a pay raise. So we voted to reject that. However, just this summer, an Illinois judge ruled that legislators, in fact, cannot vote to forego their automatic pay raise. Why? Because the Illinois Constitution doesn't allow us to do that. This ruling is being appealed, but if it stands, Illinois will owe Illinois politicians millions of dollars in back pay that they already voted to reject. And because legislators' pensions are calculated based on salary, any pay increase will also affect pension benefits. More on that later. We just discussed that the Illinois Constitution doesn't allow the public to prevent lawmakers from voting on legislative maps for which they have a self-interest. The Constitution doesn't stop us from voting on that, but, as absurd as it is, our Constitution prevents lawmakers from voting against our own interest as it relates to our pay. Unfortunately, I can go on. The University of Illinois' Institute of Government and Public Affairs reports that Illinois historical spending, this is all funds, was roughly $45 billion in 2005, $54 billion in 2010, and $65 billion in 2015. As of August 31, 2019, a month ago, the comptroller estimates that the state of Illinois owes more than $7 billion in unpaid bills. Many people believe that Illinois has a spending problem. You might ask, well, certainly our Constitution protects taxpayers by mandating that we have to have a balanced budget, right? Wrong. Illinois, some constitutions require balanced budget. Illinois Constitution it's much more flexible in this area. It simply states, put on your law caps or future law caps, appropriations for a fiscal year shall not exceed funds estimated by the General Assembly to be available during that year. In layman's terms, you can't spend money that you do not estimate to be available. One might ask, well, then you just estimate that you're going to have more money, and then it's available. There's been lots of creativity used to create Illinois' continual unbalanced budgets. For example, most Illinois budget proposals look at what's not available to spend this year because they say there's not enough money that we anticipate being received by the state this year. So they look at that amount, and then they shift that above the line expense or expenses off to the next year. By doing so, it creates a snapshot that looks balanced. Taxpayers call this smoke and mirrors. They call it deficit spending. Unfortunately, our Illinois Constitution calls this balanced. Some state constitutions impose hard spending caps. Illinois' Constitution, no way. The Tax Foundation lists Illinois as having the second highest property taxes in the country, second only to New Jersey. While some states have enacted constitutional protections that cap or limit property taxes, Illinois does not. Instead, Governor Pritzker, just the other day, a few weeks ago, signed legislation creating an 88-member task force to make recommendations on ways to alleviate the rising property tax burden on property owners. Ask yourself, if you're looking for a solution, could you change your constitution and cap your property taxes, or could you create an 88-member task force designed to come up with ideas? We'll see which one is more successful. And of course, a topic that's guaranteed to generate significant comment, maybe even in this room, is Illinois' pension systems. Most are now aware that there's a growing gap between the pension benefits owed to state employees and the amount of funding available to make the future pension payments. The size of Illinois' pension obligations is around $215 billion, yet the pension funds only have about $85 billion available for payout. The good news is it's not all due immediately. The bad news is it's still a gigantic gap. In fact, our unfunded pension ratio is third highest in the country after New Jersey and Kentucky. Our Illinois Constitution includes a provision which states pensions shall not be diminished or impaired. I agree with that provision, but I question how it's being interpreted by the Illinois courts. Some background, you may find it interesting, especially where we sit here today, that an individual named Henry Green, a Republican land developer from Urbana and one of the 1970 convention delegates, was one of the four principal sponsors, all of which were Republicans, by the way, who sponsored the pension provision that is talked about much today in the Illinois Constitution. Mr. Green, the delegate at the time, so this is in 1970, said this, I quote, "What we are trying to merely say is that if you mandate the public employees of the state of Illinois to put in their 5% or 8% of whatever it may be monthly, and you say when you employ these people, now if you do this, when you reach 65, you will receive $287 a month. That is, in fact, is what you will get." That's what this delegate, the sponsor of that pension provision, said. And I think it's very hard to argue with his logic. That's why I said I support it. The courts, though, have said something much different. The courts say that you not only get the $287 per month that you were promised, but you also get a cost of living adjustment, which automatically increases the pension by 3% each year, regardless of the size of the pension or the actual rate of inflation, and that increase is compounded, which means that it builds upon itself each year. Even the head of the teachers' retirement system has historically recognized the needs to reform these cost of living adjustments. We call them COLAs. He said, this is Dick Ingram, he said, quote, "What we're saying is that the unfunded liability is so bad is that you have to start having those conversations. The reality is that if you look at the pension math, the single biggest cost is the COLA." Okay, one more, then questions. I believe we're living in a very frustrating, if not dangerous, political climate in Illinois and around the United States. We are polarized, and the public is continuing asking us, asking me, asking all of us, public officials, to find ways to tone it down, park the rhetoric at the door, focus on problem solving, and bring civility back to public service. Some think that this is impossible, but not me. I see firsthand the results of our state elections on the floors of the Illinois House of Representatives and the Illinois Senate. By and large, Illinois has gerrymandered maps which pack Republican voters into Republican districts and Democrat voters into Democratic districts. The parties select their nominee in a primary election, and most often those who are nominated in the primary are not even opposed in a general election. Voters send lawmakers to Springfield, encouraging them to reach across the aisle and solve problems. Lawmakers, by and large, from all political parties, are good people. They want to do the right thing. However, Illinois lawmakers know that if they're from one of these PAC districts, and the truth is, most of them are, that if they get crossways with their party, they'll be challenged in their next primary. And because there's no general election to hold those primary voters accountable, what primary voters do is select the person who represents the most extreme wing of their political party. I have firsthand knowledge of this political dynamic, especially as a result of my decisions to support some very controversial issues that my own party has historically opposed. For example, this year I negotiated and supported the legalization of cannabis for adult use in Illinois. Earlier in my legislative career, before the United States Supreme Court decided that marriage equality was the law of the land, I negotiated and supported marriage equality in Illinois, something that we all have come to know as same-sex marriage. I was the only Republican in the Illinois Senate who voted for that measure back in 2013. And I heard about it from lots of people in primary elections around the district that I represent. I guess I'm still here, but the problem is that many of my colleagues look at some of these tough issues and recognize the political dynamic back home and often will say privately, "I know what the right decision is, but my district won't support it." And that's a bad dynamic that feeds from this notion that we have these packed legislative districts. I think an amendment to our Constitution could bring much needed civility to Illinois government and politics. Under the 1870 Constitution, the one that was in place for 100 years, Illinois had multi-member districts in the House of Representatives and had a process called cumulative voting. Illinois voters could vote 3 times for one candidate or spread their votes between 2 or 3 candidates. Political parties generally nominated 2 candidates for each district, and 3 members were elected per district, virtually guaranteeing that at least one candidate from each of the major political parties would win election from every district. The Cutback Amendment, a proposal led by Pat Quinn before he was serving as governor, the Cutback Amendment struck these provisions from our Illinois Constitution. I believe that was a short-sighted mistake. Consider that today Republicans largely represent downstate Illinois and Democrats largely represent Chicagoland and more recently the suburbs. Multi-member districts would mean that you'd have Republican legislators representing districts inside the city of Chicago, and you'd have Democrats representing rural downstate districts. Caucus discussions, when we meet privately behind closed doors to make choices about the positions that our party takes on public policy issues that we may go vote on. Those caucus discussions regarding hot-button issues would take on an entirely new perspective. Imagine a debate on gun legislation. You'd have Republicans from the city of Chicago arguing for more restrictions, and you'd have Democrats from downstate arguing for less. The end result would be a less polarized, more civil legislature that would try to find common ground with one another and actually solve problems. Okay, wrapping it up. Bottom line is this. We're embarking on two very significant events in Illinois. First, following the 2020 census, we will begin the 10-year redistricting process. I'm with the vast majority of Illinoisans, including the 500,000 who signed petitions who want fair maps guaranteed in our state constitution. I'm all in to make that happen, but with the courts already having ruled against us and the governor unwilling to lead on this issue, I'm concerned that we're not going to get there. That doesn't mean I won't try. Second, and as outlined earlier, our current constitution requires that Illinois voters are asked at least every 20 years if they desire a constitutional convention. The proposition for the calling of a convention will be presented to the electorate in conjunction with the November 2028 general election. When you vote then. Sure, that's 9 years away. However, and as I reminded you earlier, anyone who has been involved in elections knows that there's a ton of groundwork that must be done in advance of any election on any issue. The 1970 Constitutional Convention was years in the making. It's impossible to know where Illinois will be in the year 2028 and what sentiment Illinois voters will have on their minds when they vote in the November 2028 election. For me, I think we need to begin asking the question now of whether our Illinois Constitution provides the structure for an effective and representative government, and ultimately, whether it allows for a true expression of public will. So I hope today has helped you to begin to think about this issue, and I look forward to any questions that you all may have. Thank you.